Hey, it's your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. This is an update on Diddy's case. There have been new filings, but I also wanted to make a statement. There have been bloggers that I have been seeing that are saying that Diddy was denied bail, and that was not the case. Um, Let me just show my screen and let y'all know what's going down. So we all know that Diddy had a bail hearing on the 20. Wait, was it the 25th? He actually had it on the 25th. It was actually yesterday. Well, here's the thing. He had it on the 22nd. um, they stated, okay, you need to submit some more stuff, and we're going to go ahead and hear that on the 25th, which was yesterday, in which, as you can see, the docket entry, it says bond hearing. I'm going to read the letter that the government submitted as well as the letter that the defense counsel submitted, but I want you guys to pay attention to what this says. It says minute entry for proceeding held before Judge Arun Subramanian. The bond hearing as to Sean Combs held on 11/25/2024. Defendant Sean Combs present with retained counsel Mark and Figel. I do not know how to say that with his counsel. That's what I'm gonna say. And the defense was present, and it says the bail hearing held. The court considered argument from both sides and directed the parties to make further submissions. All right. So that's not a grant or a deny. It's just simply the court is wanting the government and the defense counsel to make further submissions so that way he can consider whether or not to grant Sean Combs bail. So he hasn't been denied. Is that they just not prolong, but they extended it because further submissions from both parties are needed at the time for the judge to make their decision. All right. So let's go into the letter that the government filed on that day, and it is a 13-page letter. So I'm gonna try to be quick. Um, all right, so it says the government respectfully submits this letter in further opposition of the defendant's renewed application for bail and following the November 22nd, 2024 bail hearing in the above captioned matter. At the hearing, the court requested that the parties address whether the defendant's conduct constituted obstruction for purposes of the Bail Reform Act. In addition, the court ordered the parties to address whether the defendant's conduct violated the court's October 25th, 2024 order, the local criminal rule 23.1, and what communications the defendant would properly be able to engage in on a prospective basis. For the reasons set below, the defendant's conduct, both past and present, constitutes obstruction, and his recent efforts to influence the jury pool are in a violation of the local criminal rule 23.1 and in contempt of the very order incorporating that rule that this defendant demanded. The defendant's arguments that any of this conduct is protected by the First Amendment are similarly baseless. Moreover, as detailed in prior hearings and briefly addressed below, the defendant's history of obstructive conduct is part and parcel to his decades long pattern of violence, which must be considered along with his obstructive conduct to fully assess his dangerousness under the Bail Reform Act. A holistic view of his obstructive and violent conduct that is still happening presently, makes clear that there is no way to rebut the applicable presumption of detention in this case. The bail package presented by the defendant does not come close to ensuring the safety of the community, including from the defendant's ongoing efforts to obstruct this case, nor does it adequately protect from risk of flight, I'm sorry. For all of these reasons, the defendant's renewed application for bail must be denied. It states the defendant's conduct constitutes obstruction of justice and poses a danger. Um, I'm just trying to read through here because I think I read this prior, but hey, let's go. So, obstruction. The court asked the parties to address the definition of obstruction in the bail context under the obstruction of the justice has been a traditional ground for pretrial detention by the courts. United States versus LaFontaine, which concluded that pretrial defendants' attempts to influence witness testimony presents danger to the community that would support detention. While the Bail Reform Act does not define obstruction of justice, district courts have interpreted obstruction in the pretrial detention context broadly to include willful actions that jeopardize the integrity of judicial proceedings. Many of the defendant's obstructive acts discussed further herein easily fall within the broad categorization and shows a persistent present effect and to improperly interfere with this criminal case. Importantly, obstructing behavior supporting pretrial detention need not rise to the level of criminal conduct. And they cite United States versus Saravola, which they found that the defendant's threat to a family member, which resulted in revocation of defendant's bail, constituted obstruction of justice because the defendant willfully obstructed or impeded the administration of justice. They also cited United States versus Kwok, which says that applying preponderance of the evidence standard and finding that the defendant posed a risk of future obstruction when he had violated orders of another court, used burner phones, made public accusations about his criminal prosecution, and provided obstructive messages to followers via video and social media posts. And then the government states that in the cases in which obstruction is part of the charges of offense conduct, like the present case, courts have detained on the basis of risk of future obstruction. And then they cited United States versus Huey. In that case, it is where a defendant was charged with conspiracy to suborn perjury related to the counts in the indictment, found that strict pretrial supervision and electronic monitoring of the defendant would provide little protection against future obstructive conducts. So you guys see how um, they state what it is that Diddy is doing. They're citing a case in which a ruling has already been made and say, okay, this is what happened in this case, and this why it should happen in this case. Here, the defendant's actions fall easily within the definition of obstruction. Indeed, there is significant evidence that the defendant has engaged in multiple acts of obstruction during the time period relevant to the charged offenses and poses a serious risk of continuing obstruction. As set forth below, these acts include multiple acts he took in an effort to stave off the instant criminal charges as well as acts he continued to undertake even after the indictment was returned in order to dissipate the potential evidence against him. hmm Oh, let's see. Then it has the racketeering conspiracy offense, and count one alleges act of obstruction as set forth in the indictment. In 2016, the defendant bribed security officers with $100,000 in cash to destroy evidence of a brutal assault of a female victim while they were at a Los Angeles hotel for a freak off. And they're going back to the transcript that says in 2016, the defendant bribed hotel security office $100,000 to make the original video go away. In doing so, the defendant relied on the intermediaries to reach out to security staff and help carry out the cover up. This act is alleged as part of the bribery, racketeering conspiracy predicate. Mm. After a victim filed a civil lawsuit in 2023 alleging, among other things, that the victim's participation in freak-offs was not consensual, the defendant made multiple efforts to interfere with victims and witnesses by feeding those individuals false narratives regarding the defendant's criminal conduct. For instance, the defendant caused intermediaries, former and current security staff, to repeatedly call a former employee, employee one, who had witnessed firsthand the defendant's abuse of the victim. The intermediaries told employee one, in sum and substance, that what she had observed was a normal relationship. Around the same time, and as highlighted at a prior hearing, the defendant recorded two phone calls with a different victim, victim number two, in which the defendant attempted to feed victim to a false narrative regarding victims to involvement in freak-offs, namely that they are consensual. The defendant has evidently deleted messages between himself and key witnesses, including a grand jury witness and victim 2 in this criminal case. One of the witnesses is witness 1, a male commercial SEX worker who participated in freak-offs and received a grand jury subpoena during the investigation. After defense counsel represented unequivocally at the prior bail hearing before Judge Carter that the defendant would not reach out to grand jury witnesses, it became clear that the defendant had done just that. Phone records and electronic evidence show that the defendant contacted witness 1 repeatedly leading up to and after his appearance in the grand jury, and then the defendant apparently deleted the messages from his phone. And in the transcript, the November 22nd transcript at 34, it states there were further communications and there were text messages through the entire period, including to August 2024 that were deleted. In the lead up to his arrest, the defendant similarly appeared to have deleted messages with victim 2, including relating to the significant monetary payments he was continuing to provide victim number 2. While in pretrial detention at the MDC, the defendant has used multiple unauthorized means of communication, which makes it difficult and impossible to monitor the defendant's communication. And that's true. While the government's substantial investigative efforts have identified some accounts that the defendant is improperly using, and the government has obtained and reduced those communications, the government has no way of knowing whether there are other PAC or Contact Me ASAP accounts the defendant is using of which the government is not aware. Put simply, when the defendant uses other inmates' accounts, his communications are very difficult, if not impossible, for BOP and the government to track and monitor. Such barriers to the monitoring the defendant have real significant consequences given the defendant's extensive efforts to taint the jury pool from the MDC, even in the communications the government has been able to identify. Even after defense counsel represented the defendant had stopped using Contact Me ASAP, he has continued to use Contact Me ASAP account at least once, one other inmate sending messages to a family member as recent as November 24th, 2024. That was Monday. And the defense lied and said that he stopped using Contact Me ASAP on November 16th. While the MDC, the defendant has instructed family members and third parties to contact multiple potential witness victims and witnesses. The defendant has provided these instructions to others by using unauthorized means of communication, which, as described above, are difficult to monitor and often using coded language. The potential victims and witnesses that the defendant has instructed others to contact include former romantic partners and former employees, most of whom have experienced or witnessed this defendant perpetrate significant violence. This is crazy. At the November 22nd, 2024 hearing, defense counsel argued that these contacts went through attorneys. However, that is simply not the case. For example, the defendant asked a family member to call victim 2. Separately, the defendant had a family member three-way dial a co-conspirator, and the defendant and a co-conspirator use code language discussing a certain blank who has to blank now and blank. Th- this is why are why is the defense counsel lying for this man? This is crazy. There was no indication that the attorneys were involved in these contacts between victims and witnesses. Like they blatantly lied in their letters to the judge. Like, "Oh, judge, we're making sure that he's following, all the rules, da 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 da," da," and yet he is not. While at the MDC, the defendant orchestrated a social media campaign around his birthday for the express purpose of influencing the jury in this criminal case. In the multiple calls leading up to this birthday post, all of which occurred on unauthorized communication channels, the defendant meticulously planned out the post. The video depicts six of the defendant's children singing him happy birthday while speaking to the defendant by phone. Was initially posted to defendant's children's pages, but the defendant was not satisfied that it would reach the correct demographic. The defendant told a family member that he had been tracking the analytics. Oh my gosh, are you serious? And directed the family member to post a video in his personal page because the defendant's social media followers are, yeah. In another call the same day, the defendant talked about the reach of the social media post and said blank. He is really trying to win the hearts of America, isn't he? District courts have detained pretrial defendants on obstruction grounds unless they cited Kiwak, in which they found that the defendant engaged in obstructive conduct, warranting pretrial detention when a message posted on one of the defendant's social media accounts accused prosecutors of bias. The defendant encouraged followers to harass victims in the case, and defendant previously used burner phones to conceal communications with co-conspirators. This is why he needs to stay in there. In another case, this is what happened. Same thing. They also cited United States versus DeGrave, where they said finding the risk of future obstructive behavior identified and articulable when defendant deleted messages, asked others to delete messages, and began communicating via encrypted messaging application. At the November 22nd, 2024 hearing, the defendant attempted to distinguish his own obstructive conduct from more violent examples of witness tampering. These distinctions are unavailing. The defendant is charged with leading and founding a racketeering enterprise that on numerous occasions committed acts of violence, including trafficking, kidnapping, and arson. Some of these acts were done by the defendants, and others were done by his intermediaries, acting at his direction. Any obstruction or tampering by the defendant must be viewed through the lens of the underlying violent conduct as well as the lens of the defendant's enormous influence and power. Moreover, the Second Circuit Court has explicitly noted both violent and nonviolent witnesses tampering supports detention on the basis of potential obstruction. In La Fontaine, they cited that case, and they stated in this case, they noted that witness tampering by either violent or nonviolent means has supported detention or revocation of bail. Like they're giving you examples of how he's obstructing his case, and they're citing really, really good cases. So I don't know. Likewise, the other courts in this district have rejected arguments like those advanced by the defendant relating to public relations strategies built on discrediting witnesses and improperly influenced prospective jurors. In the context of bail revocation, Judge Kaplan found that a similar pattern of obstructive conduct warranted detention in the cited case United States versus Samuel Bankman Fried. That case is instructive because, unlike here, the defendant was charged with a nonviolent crime, specifically perpetrating a multi billion-dollar fraud related to his operation of cryptocurrency companies that he founded and controlled, and was initially released on a 250 million personal recognizance bond, subject to conditions including home detention. However, after the defendant reached out to a witness on an encrypted messaging service, used a VPN, which prevented the government or pretrial services from obtaining evidence of the website he accessed, funneled diary entries of a key cooperator to the press, the government moved to revoke bail. The court agreed with the government on the basis of the defendant's obstruction, finding that no condition or a combination of conditions would assure the safety of the community and the consequences of witness tampering. The court rejected the defendant's alternative proposal, a gag order on communications with the press, finding that it was not a workable solution longer term, particularly with someone who has shown a willingness and desire to risk crossing the line in an effort to get right up to it, no matter where the line is. This is what Diddy is doing. He does not care about what the judge is talking about, what the court is talking about, what the government. This man is going to do what he want to do. And it's not nobody else. And I don't know, we're not looking at everybody else's cases, but let that just be a normal person, right? They will probably strip all of their privileges. This man still has access to the outside world through his family, and they want to see him get out. So of course, they're going to do whatever it is in their power to ensure that he is able to contact whoever it is that he needs to contact, so that way he can bribe or intimidate whatever he's doing. Like the government literally has this information and is providing this to the court. And the defense counsel is coming back with this BS, talking about they know everything that their client is doing. He's not doing it anymore. Blase, blase, blase. No, this man deserves to be in jail. He can't even follow the rules on the inside. Imagine what he would do on the outside. Oh my gosh. Finally, it cannot be ignored that the defendant's proclivity of obstruction appears to have continued as recently as last week in court, when it appeared that the defendant provided falsified documents to the court during the hearing convened to address his accusations of the government misconduct. And this is where, so remember, um, the defense counsel stated that the BOP investigator took pictures of attorney-client privilege documents because it had legal written on there, but the photos that was submitted from the BOP investigator did not show legal. It only showed legal on one, I believe, one or one stack of papers, but not on the other two legal notepads. But when they came to court, on the legal pass, it was written legal. So it's just like, okay, what's going on with that? So he lied. Oh, and it goes here and states this. It says, at the November 19th, 2024 conference, defense counsel represented the following about the condition of defendant's legal notepads prior to the notepads being photographed during the MDC suite. On the top of the legal pad, he's handwritten in blue handwriting the word legal. All these legal pads say legal. And then transcript, let's see, says that page was in a legal pad, and at the top of the legal pad, it was marked legal. Days later, in response to the court's order dated November 20th, defense counsel admitted that the word legal was written on the notepads after the notepads were photographed during the MDC suite. Now, there is a photo of a legal pad that was in the materials that the government gave us, whatever it was earlier this week, that does not have legal on it. So it has to be the case that on it has to be the case that as of the day of the search, November 1st of this year, that legal wasn't written on every legal pad. The inference is clear. After the BOP sweep, the defendant wrote legal on top of at least one legal pad to support his argument that the materials in the legal pads were privileged. The continued obstruction, while he had a pending bail motion, no less, should certainly be viewed in the context of all defendants' other acts of obstruction for purposes of bail determination. He's dangerous. All right. And we already know that. So I'm not going to go through this. I know they're talking about how he has a violence against numerous victims, including kidnapping, assaults, um, sex violence, arson, all of those. How he has um what is this? Firearms. Oh, and it says including when the defendant kidnapped a former employee at Pow Pow Point. Over the years, defendant's physical and essay has taken in many forms. So they're pretty much saying that this man does not need to be in the society. He does not need to be among people. Defendant's conduct violates local criminal rule 23.1 in the court's order. I'm not going to go over that. Social media posts, and it's once again, it's just the things that he's doing that he knows that he's not supposed to do. I'm not going to go and read all of this because everybody gets the gist of it. Okay, everybody gets the gist of it. Here's the thing, right? You are not supposed to use any outside communication. The government has to be able, the BOP and the government has to be able to monitor and track all of your conversations. That you're no different than any other inmate that is at MDC or in any federal prisons. That's number one. Number two, you create a bail package and you state the things that you are willing to do, but you're not doing them. For instance, I will only speak to the people that I include on my list, which is his kids, his mom, probably baby mama, right? And attorneys. But yet, he is calling them and having them do three-way calls. You're using other PACs at MDC and they can't monitor it because if you're using somebody else's, how are they supposed to know? You're doing everything that you're not supposed to do. You're trying to make posts on social media and you're looking at the to see who views. Oh, you're not getting enough view on your page. Go ahead. Let's post it on this page to see how many views I get. It's a plan with you, Diddy. You're trying to win. I don't know. You're no longer. Me personally, I have never been a Diddy fan. I honestly have not been a Diddy fan. Um, but there are still people who are diehard Diddy fans, and they're going to rock with him. And you see that when I go to his Instagram and like some of his posts, and you see these big name celebrities still, you know, standing by him. There are too many people with the same story that is coming after this man. Now, not saying all of them, because you do have your bad seeds where people are just hollering and trying to get money. But then you have those legitimate victims all saying the same thing. He is one, he's obstructing. Two, he is dangerous. He does not need to be out. He is a flight risk. If he cannot follow the rules at this jail, at this facility, he's not going to follow rules on the outside. He is going to run. I don't care what y'all say. I believe Diddy will run. I strongly believe that. I don't care he sold his plane. This man know people. He can call somebody right now. If he gets out, get my plane ready. He could pay people up under the table. Next thing you know, we wake up the next morning, this man then fled to Bali. Oh my gosh. All right. So let me see. This is document 91, making this document 90. All right. So after that letter, the defense counsel obviously gets that letter and they like, what? So they said, now this is defense. They said this short letter is in response to the government's letter that was yesterday. Was that yesterday? Is this 86? Yep, this is 86. Following Friday's conference, the defense located and da 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 da. And then this is an important safety measure that better ensures the safety of Mr. Combs and the security detail and others. So this is what I'm thinking. Now, so they're getting ready and they're getting prepared. They say, hey, look, we found this location. We're getting everything set up. We're getting everything ready. And if you give us the green light, we have everything in place. That's what they're doing. It says we have attached several photographs taken on November 24th of the building. And then obviously they ain't gonna see because we don't need to know where he's at. Then it says a security professional is coming to the location on the morning of November 26, 2024 to access the location, including the placing of the cameras and other security measures. We have also spoken with pretrial services, which indicated that in the event Mr. Combs is granted release on conditions, it would want to inspect the location prior to Mr. Combs residing there. In regard to the concerns raised by the government, the stringent measures laid out in our bail proposal include, as the court will recall, that Mr. Combs will not have access to a cell phone. Rather, the cell phone will be in the exclusive possession of the security detail, which will keep a written log of incoming and outgoing calls, text messages, etc. According, all such communications will be maintained both in written log and within the phone itself. Without getting into the merits of the government's various allegations, these conditions address them all, while also ensuring that Mr. Combs has full access to his counsel to prepare for trial and to defend over 30 lawsuits in which he is a defendant. So they're getting this ready for him. So if the judge says okay, now a few things, a security professional, nope. I need somebody that is part of the government because I feel like they will have more of a how can I see this? They'll take it more seriously. Like get fired from a federal job versus just a regular professional security job. You see what I'm saying? Um, yeah, I don't know about this. It's not good. So in reply to that, the government said, hold on. Let me go ahead and let me clear up some things. So the government responds, they submit the letter in further response to the court's inquiry during the November 22nd bail hearing regarding the applicability of the United States versus Bastani, in which it says to the defendant's proposed conditions of release. All right, so now they're talking about the conditions of release because this is the whole biggest thing. Will he be released? The government does not want him to be released. It says after reviewing the transcript, the government recognizes, that it may have misunderstood the court's initial questions. To clarify, as set forth in the government's opposition briefing and at the hearing, the government is seeking the defendant's detention based on his danger to the community, including the serious risk of obstruction of justice he poses, as well as the defendant's risk of flight. Because the government does not seek detention based only on the risk of flight, relying primarily on the defendant's personal wealth, Bastani's holding applies here. The defendant is not permitted to avoid detention by relying on his own financial resources to pay for a private jail. And then it says that the government relies on many other bases besides the defendant's wealth. So they're saying it's not just that he's a flight risk. Like we know he has money, right? So we know he's a flight risk, but that's not the only reason we want this man detained. There's more to this. This man is a nuisance to society. He's dangerous to the community. Let me see. It says, as the Second Circuit in Bastani clarified, Sabani applies only in limited circumstances where the defendant is deemed to be a flight risk primarily because of his wealth. The conditions proposed by the defendant are therefore barred under Bastani as they amount to a two-tiered system, which is precluded under the Bail Reform Act. The government sincerely apologizes for any inadvertent miscommunications to the court in response to your Honor's questions at the hearing regarding this issue. And that's it. So they want to let them know that this is not just, you know, we're not only how can I say this? Not opposing. Well, yeah, they are opposing. We're not only opposing, him to be bailed out because he's a flight risk. Their obstruction, danger to the community. This man does not need to be out. Yes, a flight risk is one, but that's not the main cause. This man has showed us that he does not like to follow the rules of the government. He continues to intimidate and reach out to witnesses and victims. And this is like really at this point disrespectful to the judge. This judge honestly have been very fair on both sides. I don't know. This, in my opinion, as I've already stated time and time again, I feel like he has reasonable accommodations and at MDC. He has access to a private conference room. He has access to his attorneys whenever he needs to. Is a Just pretend he's staying in a five-star hotel. That's it. But he's just wearing a jumpsuit and he's monitored every day, as he should be. But just to clarify, his bail has not been granted nor denied. They just the court or the judge has asked both the government and the defense counsel to submit further documents. And that's it. That's all before he makes his final ruling on the motion for bail. Okay, so I hope this clarifies everything. Tell me what y'all think is going to happen. Do y'all honestly think that Diddy will be released? And we know, so what is it's the 26th. I don't think he's going to be released this week. If he, was granted, but I honestly don't think that the judge is going to, you know, grant him bail. I really don't. But y'all tell me what y'all think in the comments below. Don't forget to like, share, and subscribe. Until then, you all be blessed. Good night. Bye.